The following program was produced by an independent community producer. The opinions expressed do not necessarily reflect those of the QATV staff or board of directors. QATV, in compliance with FCC regulations, is prohibited from exercising control over the content of independent, member-produced public access programming.
Hello, folks. I'm attorney Tom Williams, and welcome to Sound Advice. Today, folks, I'm going to do a show on trust. We're going to talk about trust, what type of trust they are, how you can set up a trust, what does it mean to have something in a trust. So if you're interested in trust, watch the next half hour, and you may end up being a semi-expert in trust. First of all, folks, the typical trust, there are two trusts. There are a revocable trust and an irrevocable trust. The typical revocable trust starts like this. It says that I, Thomas Williams, establish a trust. I make myself the trustee. I make myself the beneficiary. My son may be my substitute trustee, and my 4 children might be my substitute beneficiaries after myself. What is the purpose of that trust? Well, the purpose of that trust there would be to skip probate. It would make it so that if I had something in my name and I wanted it to go instantly to my children when I died, that would do it. Also in the trust, I can put extra language. I can say things like, if any one of my children predecease me, their children get their share. And if they have no children, then it goes to my other 3 children. And we exclude the son-in-laws or the daughter-in-laws. We don't say that, but we just don't leave anything to them, if that's our wish. The advantage of a trust is, I'm going to give you an example. If I died tomorrow and I had a trust, my child, as soon as they could obtain a death certificate, could go to the bank, show the bank a copy of the trust, show my death certificate, show the banker my son's identification, and then all of a sudden any money that I had in the bank in that trust would be given to my son. There would be no probate. And people say, well, what's the advantage of having no probate? Well, it costs around $800 for advertising fees and filing fees and closing of account fees as far as a probate. And when you hire an attorney to do a probate, it could be anywhere from a couple of $1,000s to $20,000 or $30,000, depending upon the time involved and how big the estate is. And probate takes 1 year. It takes 1 year to probate an estate before you can close out the estate, because creditors have a 1-year period to bring an action against the estate. So therefore, if you have property in a trust, as soon as a death certificate can be produced, the heirs can get the property, and it with virtually no attorney's fees and no cost, no filing fees, no anything. So trusts have been very, very popular, and that type of trust we call a revocable trust. Remember, you set it up yourself. You made yourself or your spouse, the 2 of you as the trustees, and maybe the 2 of you as the beneficiaries, and at the death of the both of you, it would 1 or 2 of your children would become the trustees, and it would be distributed to the family. And it doesn't have to be children. It can be nieces and nephews, or it can be charitable organizations. It can be whatever you want to be. But that sole purpose of that trust, or the main purpose, is to avoid probate, pass on property to the next generation. Now, sometimes, maybe if I go into a business venture, let's say if I have a couple of partners, and we decide we want to buy a piece of real estate, we might buy that in a trust and to segregate it. And we'd use the trust to segregate it from our other assets. And we would each have, let's say, a beneficial interest in the trust. So if I bought a 4-family house with 2 partners, so there was 3 of us all together, then what would happen is we would file tax returns, each one taking 1/3 of the income of the trust. They call that a K-1 return, and that's been done for years. Today, the candidate that most people use instead of a trust for buying real estate is an LLC. They do that because it limits the liability a little bit more. If you're a trustee of a trust, you might be liable for your misactions. And so if it's a revocable trust, you could be liable for the actions of the trust because you had a right to revoke it. An LLC, usually what happens is unless you as the operating manager of the LLC specifically did something wrong or omitted doing something that you're supposed to have done, you're not going to be personally liable. And so that's the big advantage of the LLC is the non-liability. But there's a cost involved, folks. When you set up a trust, the only cost is the filing fee at the Registry of Deeds and the cost of the attorney to set it up for you. Excuse me. But on an LLC, it costs around $500 for filing fee to start it up. And then there's a filing fee of approximately $500 every year that you own it. And then you have to file separate LLC tax returns. On a revocable trust, you don't have to file separate tax returns. You can just say, because this is a revocable trust, the IRS calls it a nominee trust. In nominee trusts, you don't have to file a separate trust tax return. You can just file your own tax return. So that's a big reason that people have trust. Now, there are other types of trusts, but I'm going to review another one. One of the trusts we use a lot in my practice is a trust called an irrevocable trust. And I'm sure that many of the audience have heard about an irrevocable trust. An irrevocable trust became popular ever since we've had Medicaid and the Medicaid rules. And what it says is this, is that if I own a house or a piece of property, a piece of income property or cash or whatever, and I give it away for more than 5 years, and then I go into a nursing home and I ask the government to pay for my nursing home, and I do that through a Medicaid or Mass Health application. If I gave away the property more than 5 years ago, the government will allow the gift. If it was less than 5 years ago, the government says we're going to cancel that gift because you can't give away money and ask the government to support you. Many people, what they do is they'll take their house and they'll put it in an irrevocable trust for the benefit of the children. They'll make a couple of the children the trustees, and they'll make the rest of the kids the beneficiaries. And then in order to protect their own interests, mom and dad are worried about, if I give the kids the house, where am I going to live? What happens if the kids lose my house in a card game or go bankrupt or get divorced or don't pay their taxes? I might lose my house. The mother and father, what they do is they keep a life estate on the property. A life estate means that they have a right to live there their whole life. They have a right to collect all the income that the property will produce. They have a right to take all the tax deductions they can on the property. Nobody can ever kick them out for their lifetime as long as they're paying the real estate taxes on the property. And when they die, the kids get what's called a stepped-up basis. They say, what's that? What a stepped-up basis is saying that the value of the home in the kid's portfolio will be the same as if the fair market value of the property at the date of the death of the parents who had the life estate. I'm going to give you an example. If my parents bought a house for $30,000, gave it to me when it was worth $250,000, kept a life estate for themselves, and they died when the house was worth $500,000, my tax basis would be $500,000. So if I sold the property a little bit longer for, let's say, $550,000, I am only paying tax on the $50,000. That's a great way to save a lot of money. Now, what people don't realize is Ma or Dad gives me a house. Let's say Ma or Dad gave me the house and they paid $30,000 for it. And let's say they didn't do any repairs. Well, my tax basis, if they give it to me, is the same as what theirs is. So if their tax basis was $30,000, now mine is $30,000. If I sell it for $600,000, I have to pay tax on $570,000. If the parents gave you the property and said they retained a life estate, at the death of the parents, your basis goes up to whatever the fair market value is at the date of death. So if they died, let's say, and the house was worth $600,000 at the time of death, then my basis would be $600,000. If I sold the house for $600,000, no tax. If I sold it for $580,000, I might be able to take a loss. If I sold it for $610,000, I just paid tax on $10,000. So life estate, folks, very, very important if you're going to do an irrevocable trust. It gives people tremendous tax benefits, and also gives the parent or whoever gave away the property tremendous peace of mind, because it gives them a chance to live there. When I was a young attorney, I had one person gave the property to somebody else. And I said, well, don't you want to protect yourself? And the lady said, no, my daughter loves me. Everything's going to go well. Well, the daughter didn't pay the mortgage or whatever. The property got foreclosed, and the mother lost her place to live. Okay, so it's a situation is that if you keep a life estate for yourself, you have a right to live there your whole life, and it works out terrific. Now you say, well, there's other types of trust. There's a trust called a totem trust. If I can own property and I can have it in trust for somebody, I could have, let's say I put $10,000 in the Citizens Bank, and I say I want the account's going to say Thomas Williams in trust for Gabriel Hankinson. Gabriel's my oldest grandson. So it's a Thomas Williams in trust for Gabe Hankinson. Well, during my period of while I'm alive, I could take that money out and do whatever I want to do with it, because I set up the trust. There's no formal document. It's really my money. But at my death, that goes right to Gabriel Hankinson. So lots of people, if you want to avoid probate, if you want money to go to a certain child or something like that, not a bad idea. Open up a trust account in trust for, and the banks will do it for you, and all of a sudden you could have someone get a certain amount of your money without going through probate, without going through attorneys, and it's called in trust for. And that's a better situation, folks, than using a joint account. If I open up a joint account, let's say in the same name, I have one for Thomas Williams and Gabriel Hankinson, it's a joint account. Well, Gabriel Hankinson can come to the bank and say, give me all that money. Because if it's a joint account, who's ever on the account has a right to take it. And it doesn't matter who is the person who put the money in. A joint account is subject to who's ever on the ownership papers. And it happens all the time. Somebody will open up a joint account with somebody, and the person they opened up with will get sued, or somebody will try to attach their money, or they'll get divorced or whatever, or they don't pay the IRS, and all of a sudden that money could be scooped out of that account. So folks, be very, very careful about opening up joint accounts with your children, because if your kids get into financial trouble, you can lose all your money. Also, if they're not in financial trouble, if it's a joint account, they can go there and they can take all the money out themselves. They just go to the bank and say, well, it's a nice weekend, I think I'll go to Foxwood, and they can take all the money out. In trust, they can't do that. Now, one of the things that I've used a trust for a lot is managing the family money. And I'm going to give you a scenario. We have, let's say, mother's alive, dad died, and let's say mother has $300,000. That's a lot of money. And she has 4 kids. And she has one that lives close to her. And the one that lives close to her, she says, well, look, you're doing all my banking, you're doing everything for me. I'm going to make the account joint with you. And then what happens is when I die, you can give it to your brothers and sisters, but I want you to pay all my bills right now. Folks, it's dangerous. Don't ever do it. Number one, the kid can run off with all the money and the mother can't say anything about it because it was a joint account. Number two, when the mother dies, the kid could say, Ma loved me the best. The money's all mine. Number three, the kid could get sued. Maybe they got a car accident. Maybe they didn't pay their bills. Maybe they didn't pay their income taxes. All these things can happen and your money could disappear. How do you beat it? You open up a trust. If you have a trust and it says, let's say it's under the Williams Family Trust, and I'm the trustee and I'm the beneficiary, but at my death, I'm mental incapacity, my son's the trustee and beneficiary. What does that mean? That means that while I'm alive, I can run this whole thing. And while I have all my mental abilities, I can do it. I can run the whole trust. But if I'm declared mentally incompetent, the income and the principal of the trust is still going to me, but now my son's in charge. Nice. And when I die, it says everything goes between my 4 children. skips probate, easy to administer. All my son has to do to get all the money out of that bank account is go right down to the bank with a death certificate. He's the trustee, he can get all the money out, pay my bills, and give everything to the children. Many, many people use those today. That's called a revocable trust. And it becomes irrevocable when you die because once after you're dead, you can't change it. But one of the beauties of a revocable trust is, and I gave you the example that I have 4 children, hopefully I will have longevity. And if I have a long life, maybe when I'm in my 90s, maybe I say, I don't want to leave everything to my 4 children. Maybe I want to leave it to my grandchildren. Or maybe one of my grandchildren or great-grandchildren have some kind of learning disability or physical disability that I want to help them out. They need it the most. So I could redirect things. Or maybe a couple of my kids won the lottery and they got plenty of money. But there's a couple that really need the money. So I have a right to change the trust. Revocable means I have a right to change it. So until I die, I have a right to change it. So that's a revocable trust. There's trust that if I'm holding some money for somebody, and it's really not my money, it's their money, that's a trust, folks. And a lot of people don't realize that that type of trust exists. But if somebody's holding money for somebody else, and it's not their money, they call that a resulting trust. If you're holding something for somebody else, it's really not yours, it's a resulting trust because the result is it's not yours, it's somebody else's. Something to be aware of. How do you establish a trust? Trusts are kind of easy. You sit down with an attorney. You tell them what your need is. Who do you want included in the trust? When your children die, who gets it? Those are the questions. Those are important questions. Now, who's the most important person to have an estate plan and have things like trust, wills, powers of attorney, all that? Folks, it's the single person who doesn't have a spouse, who has no children. Because their heirs are their mother and father. Now, maybe their mother and father are 90 years old, or maybe they're dead. Then their heirs become their brothers and sisters. And then if they have deceased brothers and sisters, they're in the mix. So it gets to be a horrendous item when somebody dies. Who are the heirs? Who should take? That's a big reason, folks. Especially if you're single, make up a will, see an attorney. And then if you want to do a good estate plan should have a power of attorney, a healthcare proxy, a will, and a trust. And if there's a deed the property to the trust. That's a good estate plan. And if you're over 69, 70 years of age, give a lot of consideration to the irrevocable trust because those will protect the asset in the future. Those are good things to have. If you want to set something up in an irrevocable trust so it's out of your ownership for 5 years. When you sell real estate that's in a trust, no problem. You can just like a regular property. Sometimes, though, trust might say, I need the beneficiary's consent. So in that case, you might have to go around having the beneficiaries sign off saying, well, I give my consent to the sale. Sometimes you don't need that. Depends what the trust says. If you have a trust, be familiar with it. Read it. I'll bet you that 99% of the trusts are never read by the people that have them. Folks, they just say, oh, they trusted the attorney. Well, folks, there's lots of forms can be generated in a lawyer's office, and you can't be right that form's exactly right for you. So what you want to do is just read the trust, understand it. If you want to make some additions to it, most of these revocable trusts, they can be amended. So that's just a good idea, sound practice. That'd be sound advice from Attorney Tom Williams. If you own property and trust, real estate, Fannie Mae and Freddie Mac says that that's a permissible ownership. So consequently, you may have property, if you want to refinance or sell your property, and you have it in a revocable trust, it is a permissible ownership under the Fannie Mae rule guidelines. An irrevocable trust is much different. It's very hard to borrow money if you have an irrevocable trust. So if you're thinking about borrowing money, think about borrowing the money first. I have a friend of mine who's in the mortgage business, and he tells me that they'll let people, they'll lend money to a revocable trust because under the Fannie Mae guidelines they can do it, but under the Fannie Mae guidelines they cannot give it to an irrevocable trust. So that's something important for you to know. When you have a trust, when you go to see an attorney about a trust, be honest with how much financial assets you have. Be honest about what you have for real estate and what it's worth. And if you don't know what something's worth in real estate, you can go and see what the appraiser for the town says it's worth. Usually the appraiser is pretty close to what things are worth in Massachusetts. So you want to see what it's worth, because if you have more than $1 million, the lawyer might set up separate trusts, AB trusts for the husband and wife. And if he does that, he's trying to eliminate the estate taxes, because there's a Massachusetts estate tax on everything you have, which is more than $1 million. Well, folks, if you take what you have and you give half to mother's trust and half to dad's trust, let's say you had $1 million, now all you have is $500,000 when you die. So consequently, there's not going to be an estate tax. That's a big saver, a significant entry. So, and that's with the use of a trust. Trust, it's legal, as I said, to have a trust for Fannie Mae and Freddie Mac for refinancing, for as long as it's a revocable trust. On irrevocable trust, sometimes it's more difficult. So you have to make sure what type of trust you have and review your trust material. I've had people come in, I think I had 3 appointments this week that I did work for people 15 years ago, and they want to know if the work is good. I say the work is still good, but your needs are different. 15 years ago, they had revocable trusts on their house because they said, well, I don't know if I'm going to keep the house for the rest of my life. Maybe I'll sell it. Maybe I'll go to Linden Ponds. Maybe I'll retire down the Pine Hills in Plymouth. Maybe, I don't know what I'm going to do. If that's the case, usually the attorney will put it in a revocable trust that will skip probate, but will give the parents the complete freedom what they want to do. But once they found what they want, or if they decided, if they said, I want to stay in this house as long as I can for my whole life if I can, then what do? We put that in an irrevocable trust, and we have the children have a life estate. What's it cost to at the Registry of Deeds to record these documents? To record a deed, it's $126. To record a trust is $226, and that's basically what you need to record the deed and the trust. Then you have to pay the attorney. When you're working with an attorney, once he starts to get involved a little bit, ask the man what he's going to charge. If he says if you're doing things like trust and wills, and he says, I'm going to charge you by the hour, ask him, how many hours is this going to take? If the lawyer can't tell you how many hours it's going to take, then you better say, I think I better get myself another lawyer, because you don't understand what you want to have to do. Now, in some cases, it's so complicated. I had someone come to me last week, and their father died 10 years ago, and they had a big stack of papers that they started and they never finished. There was all kinds of insurance policies to collect. There was estate taxes to do. There was just a horrendous amount of paperwork to do. And they said, well, how much is this going to cost? And I legitimately said, I don't know. I says, I'm going to have my secretary do a lot of this. She's going to bill out at a certain rate per hour. I'm going to do a lot of it. I'm going to bill a certain rate per hour. And that's how we have to tackle that problem, because it wasn't the average problem. The average problem, somebody comes into your office, and what happens is this. They say, well, they want a power of attorney, a healthcare proxy, a will, and a trust. You can do those things. You know how long it takes you to do it, and that's what you do, okay? But when people have problems, when they want you to contact insurance companies for them, try to cash stock certificates in for them, when they have to do all that type of work, sometimes it gets a lot longer. So in fairness, you have to establish a rate and tell the person it's going to cost them so much an hour, and then keep the people updated. The lawyer has to keep the people updated and say, well, look, I spent 5 hours this week or 10 hours or whatever. And the lawyer should be able to, when they talk to the people originally, give them an idea how many hours it's going to cost so you can budget for it, because people aren't made of money, and what happens is they have to have an idea of what to do, and that's a good way of doing it. If they have joint accounts, sometimes can have what they call a totem trust, and this is kind of different. They call it a totem trust, and what it is, if my mother sets up a joint account with me, and she says the purpose of that trust is to pay all her bills, and when she dies, she wants me to give it to the rest of the kids, then there's no written trust agreement. It's just an oral one, and they call that a totem trust. So there are many lawsuits that when the mother dies, the kid has a bunch of money, they put the money in their pocket. The other kids come after them with a lawsuit and say, look, a mother never wanted to do this, and you have what's called a totem trust. You just had the money was put into your name for convenience and not for you to get it. So then it goes back and forth as to who has the duty to prove that the money was put there for convenience. And maybe there's some oral testimony from living people. Maybe there's some written documents. But basically, the person that has the money has to show that, look, I have this money legitimately. This was not money given to to me because of just my name on the instrument. My name was on the instrument because I was the trustee for the dog bound trust, and I took care of all the dogs or whatever. So that's how that works. So I guess the purpose of the story, the finishing up this little conversation about trust is that you have to understand, number one, what's the purpose of the trust? What are you trying to accomplish? And I think before I went to a law office and said, look, I want a trust, I think I'd tell the lawyer the facts. This is what the facts are. And based upon these facts, I think I need a trust. What do you think, Mr. Attorney? And they'll give you some ideas. I had some people come to my office last week, and they were all set for some irrevocable trust. They were afraid about nursing homes. They wanted to give the money away from their mother. And then all of a sudden, I talked to them. They said, well, does mother need any money? Yes, mother had a basic need. She needed more money. She didn't have enough money in Social Security. So I said, but they were concerned about saving the house. So I said, this is what we can do. We can deed the house to the stay-at-home daughter. There was a stay-at-home daughter. And because she's taking care of her mother for more than 2 years, Medicaid says you can do that. So it's a Medicaid permissible transfer. If the mother went into a nursing home right away, she has nothing to worry about. So that's big. We kept the life. We deeded the property to the children, to a child, and the child that I deeded the property to is going to get the Hope thing. But she's taking care of mother for more than 2 years. Since she took care of mother for more than 2 years, while mother was going into a nursing home or about to go into a nursing home, the government says that transfer was okay. We didn't have to take the equity value of the house and pay off the children. We just gave that. The whole thing went to the good daughter who was taking care of the mother. That daughter has a right in the future to take that money and give it to her other brothers and sisters, give the house if she wants. But she can also say, hey, I took care of Ma, I want to keep the money. So that's how you can use trust, and you can use gifts to avoid paying for the nursing home. When you do your trust, what other instruments should you have? Folks, everybody, even if you're using a trust to avoid probate, you want to have a will, because you don't know when you're going to die. You don't know what you're going to have when you die. A trust will provide for you there. It will help you, because maybe not all your property is under the name of the trust. The only way you get property under the name of the trust, you have to label it. You have to go, if it's real estate, you record a deed, transferring it to the trust. If it's financial assets, you got to go to the bank account. I picked on the Citizens Bank earlier. I'll say you go to the Citizens Bank and you say, look, I want to change the name of my account to the XYZ Trust. If you have stocks and bonds, same thing. You have to talk to your financial analyst or whoever is doing your stocks for you and say, look, I want to change the name of my account to the XYZ Trust. At most, I've seen people charge $15 for doing something like this. And many times they do it for free. So you want to make sure your assets are in the name of the trust. By doing that, that's how you avoid probate, and everything's in the trust. And then you have to decide whether or not you want a revocable or irrevocable. And basically, that's based upon the purpose of the trust. And I want to thank you for watching the show, and I hope you found it interesting. And I'll be signing off until next week. Thank you.